Judgment in the matter of the Independent Workers' Union of Great Britain against the Central Arbitration Committee and another.
Lady Rose will hand down the judgment for court.
This appeal concerns the collective bargaining rights of a large group of Deliveroo riders working in the Camden and Kentish Town area of London. Deliveroo is a well-known online food delivery company. It relies on its riders to deliver food and drink orders to its customers. This group of riders joined the Independent Workers' Union of Great Britain, known as IWGB. In November 2016, that union made a formal request to Deliveroo to recognise the union for collective bargaining in respect of riders in Camden and Kentish Town. The union wanted to negotiate on the riders' behalf to improve their working conditions. Deliveroo rejected the request. Where an employer refuses to recognise a union may make an application under Schedule 1A to the Trade Union and Labour Relations Consolidation Act 1992, which I shall refer to as the 1992 Act. The procedure set out in Schedule A1 may ultimately result in a method of collective bargaining being imposed on the employer. The union in this case made such an application to the Central Arbitration Committee, known as the CAC. The CAC is the quasi-judicial body which, under Schedule A1, has power to order an employer to recognise a union and engage in collective bargaining if certain conditions are met. One of those conditions is that the people the union seeks to represent fall within the 1992 Act's definition of workers. The CAC, having analysed the nature of the relationship between the riders and Deliveroo, decided that the riders in question were not workers within that definition. It rejected an additional argument made by the union that refusing to recognise the union would breach the riders' rights under Article 11 of the European Convention on Human Rights, or ECHR. Article 11 protects the general rights of freedom of peaceful assembly and freedom of association with others, and it has a specific right to form and join trade unions, which applies in more limited circumstances. The union sought permission to challenge the CAC's decision by judicial review. The High Court granted permission for the union to bring its claim on one ground only, that the CAC's decision breached the riders' human rights under Article 11. Accordingly, the union's challenge in the courts proceeded on the basis that the riders do not fall within the domestic definition of worker under the 1992 Act, but that this definition should be interpreted more broadly to include the riders to make sure that the legislation complies with their Article 11 rights. That kind of broad construction is made possible by Section 3 of the Human Rights Act 1998, if the ordinary meaning of the words used in the legislation would lead to a breach of someone's rights. The High Court rejected the union's argument and dismissed its claim. The Court of Appeal upheld the High Court's judgment, and the union now appeals to the Supreme Court. The Supreme Court unanimously dismisses the union's appeal. The first issue is whether the riders fall within the scope of Article 11 of the Convention, such that they benefit from the right to join and be represented by a trade union. The case law of the European Court of Human Rights, sometimes referred to as the Strasbourg Court, is clear that the right to form a trade union only arises in the context of an employment relationship. The concept of an employment relationship for the purposes of Article 11 is a free-standing concept, and it doesn't depend on the definition of workers or employees used in the domestic laws of all the different countries which have signed up to the Convention. The Strasbourg Court has held in its earlier cases that to decide whether there is an employment relationship for the purposes of Article 11, you must have regard to the factors set out in a recommendation issued by the International Labour Organization. That recommendation directs that the assessment of such a relationship should be guided primarily by the facts relating to the performance of work and the pay of the worker. How the relationship is characterised in the wording of any contract between the parties is of secondary importance. The correct approach requires a court to consider many different factors, focusing on the practicalities of the relationship and how it operates in practice. Applying this approach to the facts of the case, the Supreme Court holds that the riders do not have an employment relationship with Deliveroo for the purposes of Article 11. The CAC had rigorously scrutinised the substance of the relationship between Deliveroo and the riders. It examined in detail how the contract between Deliveroo and the riders operated in practice and looked very carefully at whether what was written in the formal contract genuinely reflected the true relationship between the parties. The CAC made a number of particularly significant findings. First, the contract between the riders and Deliveroo gives riders a broad and virtually unfettered right to appoint a substitute to take on their particular job. This right on its face is totally inconsistent with there being an employment relationship. Usually in an employment relationship, you have to go to work and do the job yourself, and you're not allowed to just send somebody else along to do the work for you. The CAC found that Deliveroo did not police a rider's decision to use a substitute, and riders would not be criticised or punished for doing so. Secondly, the CAC found that the Deliveroo riders did not have to make themselves available for work at any particular time or for any particular number of deliveries. Again, in an employment relationship, usually you cannot choose whether to work or not, and the employer sets how many hours you must work and when. The riders here were free to work or not as convenient to them. Finally, the CAC found that Deliveroo did not object to riders working at the same time for Deliveroo's competitors and doing deliveries for other companies at the same time as making a journey for Deliveroo. Usually, an employer will not allow people who work for it also to work for competing firms. In all the circumstances, the CAC was entitled to conclude that the provisions in the contract genuinely reflected the reality of the relationship and that was not an employment relationship. As the riders do not have an employment relationship, they are not able to rely on the trade union rights conferred by Article 11. The court went on to consider the scope of the collective bargaining rights that Article 11 confers on those workers who do have an employment relationship. The court concluded that it would not be a breach of Article 11 for a state such as the United Kingdom to decline to legislate for compulsory collective bargaining. The Supreme Court therefore unanimously dismisses the appeal. The CAC's decision to reject the union's application to require Deliveroo to negotiate with it stands.
Thank you.